filed the notice yesterday, so we're officially on the docket. The case is with the Supreme Court. The time on getting briefs submitted and such is essentially stayed for a period here until all the transcripts are received by the Supreme Court, which may take a while in this case just because we requested all of the transcripts from all the pretrial proceedings as well as the trial. So it may take some time until those transcripts are actually received by the Supreme Court, at which time we'll have 30 days from that time to file our initial brief.
Now, specifically, what are you asking the Supreme Court to do?
Well, we have numerous issues that are going to be briefed. What we're asking for is the court to reverse certain decisions by the district court and to send it back down to Missoula County in the 4th Judicial District for a new trial. And I guess, there are several issues that will be addressed on appeal. One of primary importance will be venue. It's our, and obviously we respect the trial court and the judge's decisions, but, we disagree. And we believe that Markus was not going to get a fair trial in Missoula County, and that's not to say anything about the jurors or their honesty or integrity or anything like that. It's just saying that when you have so much media attention, sometimes despite any efforts to get rid of any preconceived notion on a case, you just can't disregard them. And ultimately that can sway a juror whether or not they intended it to or not. Some knowledge you're going to know going in, and it makes it more difficult to get a fair trial. In particular, the criminal history issue, when his criminal history was published prior to trial, we'd previously gotten criminal history sealed and excluded from the public. But when that was published through the Missoulians' own investigation, that's highly prejudicial. That's inflammatory. And we believe that at that point, if it was prejudicial enough to be sealed and excluded, then it certainly, in our opinion, it was prejudicial enough to warrant a change of venue. And there, again, we documented, probably 450 local articles in the Missoula community on the case, and a lot of it was it was covering things outside of just what was occurring in court. A lot of things about memorials and, criminal history, just other incidents that we believe could have ultimately tainted the jury pool. And again, I emphasize that we respect the jurors and we respect the court, but at the same time, we're not saying that people were dishonest. We're just saying that, it's like if it's messaging. It's just once that message is in someone's head, it's very hard to disregard any preconceived notions that a person has, whether or not they're, attempting to do so or not. And then we also, consistent with our motion for a new trial, asked that the jury instruction, we asked for a new trial based on the jury instructions. We believe that it was error to instruct the jury on justifiable use of force in defense of persons, because we thought that this case fell squarely within, our affirmative defense of justifiable use of force in defense of an occupied structure. It's an affirmative defense. It belongs to the defendant, and in our opinion, it was an error to raise an affirmative defense for the defendant over our objection. So, and again, the standards are very different when it comes to justifiable use of force in defense of a person versus an occupied structure. And by raising the justifiable use of force in defense of a person over our objection, it essentially heightened the burden that, Markus had to establish in order to get a not guilty verdict, to one where he had to be in imminent apprehension of serious bodily injury or death, versus just, assault or a forcible felony, which is the applicable standard for an occupied structure. So there are a couple of issues that will be addressed, but there are many more.
Now, what about the charge of mitigated deliberate homicide?
Right. And so what we asked the district court to do at that point was just to look at the evidence and, take it all and consider a lesser conviction. Again, that's pretty much left to the discretion of the trial court. Whether or not that will be appealed is yet to be determined. The motion for a new trial, that issue will be appealed, but, in some ways we'll just be arguing that he just didn't receive a fair trial and it was a violation of his due process rights. effectively due to those what we believe to be errors.
Okay. Now, is there a specific timeline? You had mentioned there's a lot of briefs that need to be filed. Does the Supreme Court give you a time limit?
Yes. The time limits don't trigger until the record has been transmitted to the Supreme Court. And what I say when I say the record, I mean transcripts, and that means that the clerks have to go through and actually transcribe everything that occurred. The party, what they said, the next party, what they said. So, as you can imagine, all the pretrial litigation, the hearings in chambers, the jury trial, sentencing, all of that stuff needs to be put in writing and, identifying the parties, etc., and then sent to the Supreme Court along with all the exhibits. So that can take some time. And once that's received, that will trigger our 30-day time period to file. In most cases on appeal, a lot of times an appellant will request additional time, and, commonly that's granted by the Supreme Court to submit the briefs, because once you get the record, then you need to start incorporating the record into your briefs, and that too can take time. So it may be a lengthy process, but
allow me to ask you this. Why do you believe that the Montana Supreme Court might be more favorable to your arguments than the district court was in Missoula?
Well, I don't necessarily. What we're arguing is, we're arguing that the legal standards that, applied to this case, in our opinion, should have warranted certain conclusions by the court. So, it's important to emphasize that, when you're an attorney, you have to respect the district court. We have a great respect for Judge McLean, as well as the jurors and the process. That said, we're going to have several judges, looking at it. And again, there's so many things that are brought up at trial and pre-trial that, it's just a different level of review, and it's an important level of review. So each assignment of error, each issue that's going to be raised, when it goes up to the Supreme Court, we're going to get a second look at it, and we believe that some legal conclusions were made and that we just disagree with.